and in the meantime, picked up a lot of rentals with creative, legal, inventive approaches that were both good for the buyer and good for him and good for the seller, which I've pretty much found to be the key. You've got to have the right paperwork to do what he's going to talk about, and you need to have a deal that's structured in a way that benefits in some way both the buyer and the seller, not just the buyer. Although I think we all benefit from, to the extent you at least understand lease options, you understand the benefit of structuring your deal that way. So I guess that's probably enough. I think we want to get started and get Jack going. So without further ado, I will introduce you, Jack. You're up.
Thanks, Charles. The host disabled. Cherry.
You are now the host.
Oh, that's me, huh?
Yep.
Okay, guys. Thank you, Alex and Charles. Charles, is one thing, not airline, Air Force. There's a difference.
I didn't say airline, did I?
Yeah.
I think. Yeah. Oh.
Okay. Well, I'm happy to be here, and I look forward to this. I've learned a lot with these real estate meetings. When I first moved to Florida, I got a real estate license, and Lowry Nickerson had a club meeting, or had a meeting with the graduates, and I thought, well, I'm not going to tell anybody all these secrets I've learned, but I went to the meeting, and there was a lot of sharing. This is not a zero-sum game to tell people what, there's millions of deals out there in the Tampa, St. Pete. There's a million people in Tampa, a million people in St. Pete, Pinellas County, and the South Florida area is no shortage of real estate and all that. So I found a great benefit from meetings like Alex, and I first took a seminar from Jack Miller about options, and I thought he said, you don't need much money, you don't need much experience, you don't need talent, brains, whatever. And I said, that's me, that's my bio up there. I have all of those. No money, no experience, no talent. But so I started buying options out of necessity. I had very little money. And after some years, I found it was a pretty good procedure. And then I delved into it more and more. So after the more I got options, the more I continued. And when I, after some years, could write a check for a piece of property, I kept doing options, including I ended up optioning my own house. And on the option purchase or lease option, I don't use the word option. I use the word lease purchase. And I can quit, and the penalty is that my past payments are retained by the buyer, so that it's better to quit, which I have on a few occasions, than to proceed with a bad deal. If you get a deed, you got the deal, whether you like it or not. Charles asked me to say, what is an option anyway? It's a method to secure an uncertain financial position in the future for the payment of a fixed sum at the beginning. It results in a unilateral contract. It changes a bilateral contract, like a purchase contract, to a one-way contract you can exercise or not exercise. The payment option money is not taxable to the seller until it's it's exercised or abandoned. That could be 5 years later or whatever. So the consideration is required for a valid option. It could be a lump, some money, it can be installment payments, or performance on a lease is the only non-monetary way to get an option, that being a lease, having a lease is considered compensation. So to do those things, options are pretty simple, but you need two people, you need two amounts of money, the option money and the exercise price, and you need two dates, the date you do form it and the date of the exercise. And you can make, in a class I show, you could take a blank piece of paper and do those two people, two dates, and two amounts of money, and it'll stand up in the Supreme Court. That's what's required by law, and it's easy to write down. But if you don't get it all right, then you have a sort of a void contract. So, but anyway, so options have been good to me, and like over time, I've discovered some you know, further benefits. So how do we get back to the beginning? Let me get back here. Okay, so we had. So one of the things I learned after about 5 years is how to get the tax benefits of real estate, like the depreciation, uh, the interest deduction, the tax deductions. And at the end of the day, when the property sells, you could do a tax-free 1031 exchange without ever owning the property. Does that sound curious? I think it should. It should. People should not be gullible and think, or you know, that's a bit unusual. But I show people letter and verse IRS rules. As 10 IRS has 10 requirements for the tax benefits, and we have 9 of them. We have all items on the IRS list. The only thing we don't have is our name in the courthouse. And it's sort of like an agreement for deed. The fellow gives you agreement for deed. He has the deed and you have an agreement, and it's legal. It's done all the time in the tax code. So on the way out, we'll talk later about 1031 exchange is a strategy that's open to everybody. That I have a 1031 exchange company, was the first one in Florida in 1986. The day after they changed the tax code, I started an exchange company, but I was prepared. I had documents from Chicago Title and Trust and with the attorneys. So we started, we've done thousands of them, and it's simple and easy to do, as Charles would tell you. It's $750 is modest. So lots of people do it, and some people either are told by a realtor or maybe an attorney, it's too complicated, don't do it, pay the tax. I can't hardly think of any situation that would warrant just paying the tax when you can exchange into any type of real estate or an option. Options are, that we're going to talk about here, options are exchangeable. They're a title right in real estate, and it's treated like real estate. So I found with the tenants, I did a few tenants, and they behaved better. I gave the tenants options, and we got a little higher rents, we got less turnover, and a little less maintenance, a little bit, but they're not going to put a roof on your house, but they might fix a drippy faucet. So they liked it better. So I gave in the beginning of the 80s, Mark Warda, who is my partner and trustee and the author of the land trust book, which we're going to talk about later. So I gave all my tenants an option. I thought that was clever. And then one fellow didn't pay me. And I called Mark. He said, well, throw him out. I said, I tried. And he hired an attorney. He did what? Okay, so we had to go to court. We sat in Clearwater in the courthouse in the courtroom, and the judge said, you cannot evict a tenant with an option. He has a title right, and you must do a foreclosure. And Mark and I looked at each other and said, what? We do? So we both got a seminar that cost me, it was my $10,000 seminar that, 9 months later, I got the guy out because after spending $10,000 on a foreclosure situation. So that's, we had sat down, and that's how we came up with the contract for option that we can talk about later. It looks like an option, sounds like an option, but it's a virtual option. It's not quite an option. So they're a tenant then. So the contract of option has after. I always think I know what I'm doing till then I don't know what I did, and I look for a solution. So we figured it. But another very powerful use for options is in your IRAs. You get the high leverage, low risk, and it's a great tool to pump up your IRA for the future, which is unknown, as some people were saying earlier about the virus, and we've never seen situations like this. So the future I can't see around corners. So I have IRAs. My wife and I have some different IRAs, and there's a lot of other uses for options. So I would hope that people will pick up on the value of this. And there's no other book that I know of in the country that explains the depreciation, the tax benefits, and all this. So the course is on my website. Anybody likes it, the book and the all-day video. So anyway, there's other uses for the option. These the documents that we're using were okay. So I'm going. There's thousands of investors coast to coast have taken these courses and are using it and making the documents, making deals. And I've started teaching this course in the late 80s and all over the country, up and down, a lot in California. And many people have gotten on and using it, and we talk and with these, I'll answer questions 2 years later or whatever, and sometimes we find some things that we didn't have included. The first 10 years of these documents were we made changes. Well, we found that we needed a little clause in the option agreement considering insurance or other things. So by use, we found okay, we need to make an improvement here, close up this gap. So after 10 years, and I had about 70 some houses, and I had some with Howard Cook, and we had some together. So we had 100 houses under management. And for 10 years, we had 1,000 house years. We made several changes. And the next 10 years, we didn't find any change. We finally had covered the gaps in the law. So the next 10 years, same 100 houses, we didn't find anything other, maybe something minor. So they're proven documents. The procedures are battle tested. And that's not say, well, I'll try it. I hope it works for you. And like say, the contract. Other thing that you can use the options for, other than real estate, is personal property. And we have, I do notes. I am owning mobile home parks. I've had to own mobile homes. That's personal property. And notes, and you can, cars, boats, airplanes, any kind of personal property, you can option, sell the option to people. A lot of people get a good deal, get an option, take it to a meeting, As probably, Alec, you might have seen that somebody comes with a contract that's got some more fat left and sell it for 5,000. Does that ever happen, Alex? I would think I've seen that happen, and let somebody else close the option and make the profit. So personal property is a candidate, as I say. You can, well, I option notes, but receivables from tradesmen. The tradesmen that you know and that you hire, and there's some online, there's a roofer or a kitchen contractor or plumbing contractor that's done some big jobs, and sometimes they don't get paid all the money, and sometimes they don't get paid, and they have receivables. I ask what contractors I use, you have receivables? Yeah, and you can buy them from them at a discount, but we really option them. We don't exactly, or we don't purchase the receivable. So you can option leases and other intangibles are all items that can be valid for an option. Options are very well grounded in the law. There's options all over athletic or contract options. There's options on everything in the world. There's the Chicago Board Option Exchange. There's trades options. And when I got out of the Air Force, I had a friend and I had, we didn't have much to do, so we developed a method of selling puts and calls options on stock that we didn't own. That was kind of sporty. So we developed a system that we won more than we lost. So there's options are well grounded, lots of court cases. Mark Warda wrote the chapter, 4 pages of legal of all angles of option litigation and what the result was. So these are pretty well battle tested, and you can rely on them. So anyway, I say there's more on my website, jackshearealestate.com. There are blogs and articles and other things, and that option course is there. So anyway, Alex, that's pretty well down the line. Why don't we entertain some questions and find, get the gaps or the missing, what was missing?
All right, anyone? If you'd like to ask a question, you'll have to unmute yourself.
I'd like to ask a question and make a comment. Have I got the floor? Everybody hear me?
Yes, Jack, you have a question.
Jack?
Yeah, I hear you.
Okay, well, I'm probably
Ray.
one.
We're talking to Ray?
Ray Smith.
Yeah.
Probably one of the few people here who know who Al Lowry is and went to his seminars, and Jack Miller and a few other names that you mentioned, because that was a while ago. So some of these guys probably weren't born or in high school when Al Lowry was going around doing his seminars. But I've used options too. I found what you said was very exciting. I didn't know, and I belong to the Exchanges Club. We do a lot of the things you mentioned there, of course, and Jack Miller, some of the other guys you mentioned were big in the Exchange Club. But I didn't know that you could use 1031 on options. So with all my 60-something years in real estate, I learned something new in this last 10 minutes. So I thank you for that, Jack.
Well, that's, you're welcome, Ray. And somebody wanted to exchange an option. The attorney at a title company said, no, you can't do that. That's illegal and blah, blah, blah. So they called me. I said, no, that's not true. That's not true.
Well,
I know the tax code. So they moved the closing, or I did an
Yes, that's
exchange
me.
for their option. And you can
Right.
exchange it for real estate, or you can exchange it for more options. So they can go back and forth both ways, Ray.
With deferred tax, with the tax,
Yes,
any profit deferred and moved into the other property. That's
yeah, it's
that's
suspended until it's sold.
beautiful, beautiful. All right, I'm good. Thank you.
I have a question. It's Lynn. Do I have the floor?
Yes, go ahead.
Okay, thank you. So my question is, I'm, in theory, I understand how all this works, but there is a lot of moving parts to it. So I would ask you, Jack, and thank you so much for sharing what you shared so far, a lifetime of learning. Where would you suggest, like, especially people on the call who are just kind of starting out, or someone like me who just wants to learn more about it, like what would be the first thing you would read, like your book or certain blogs on your website, or like, could you just give us kind of a little bit of a, say, do this first, do that first, if you want to learn, not if you want to actually put it in practice, but let's just start with the learning. Where would you start?
Okay, Lynn, you see that book?
Yeah.
Okay. That book, and I mean, the way to really get a handle on it is a course on my website, which includes this book and a CD and an all-day video, Lynn, of a 9 to 5 classroom
Right.
video. There's a lot to it, but I'd say there's lots of people can do it. There's a couple of pieces of paper, but once you do one, so the course is a sit and watch the video, say taking an hour at a time, and it goes through kind of my slides, except pages and pages, that gets into the court cases. And at the end of the day, if you go through the book with the video and mark it up with the highlighter and arrows and stuff, and you can take it in pieces. And a year from now, if you have a situation about optioning, exchanging that, you can go back and run that chapter over again. When you take a live class like now, you try to remember the best you can and you make notes. But there's nothing that I say, people like the video, and especially I have comments from people all over the country that English is not their first language. And we kind of talk in colloquial stuff, and we say, gotcha, and we say, and they don't, that colloquial language is a bit unusual for them. So my suggestion, if you really want to, excuse me, want to master this, is take that course, download the course, and I review documents for you. You do a document, you email it to me, I'll review it, I'll call you and say, okay, here's what I suggest. And then I delete the stuff. So you could make one up or have a real thing. I don't keep the stuff because I'm in the middle of thousands of people's exchanges and stuff. So I make sure that you can do it, and the same with trust, that I will review documents, and 2 years from now, you can call me up and ask a question, and I'll answer. I'm the Maytag repairman here, Lynn. I said, I'm hoping the phone rings, okay? I'm a lonely guy.
Great. Well, thank you so much for these suggestions and the advice.
And guys, could I jump in for a second? I want to add something just because, because Jack was gracious enough at mine and Alex's invitation to come and talk to us. We're not, trying to push courses down your throat or anything, but it's complicated but simple at the same time. It's not that complicated. It's like anything that you've never done before. It's new, And I've done, I don't know, 10 or 12, I guess 12 deals now. Really, what I think are, for me, were really top-notch deals based on the lease option structure. And the reason that you need to kind of hear the presentation is that Jack walks through in 8 hours. I mean, it takes a while to get the material and the information out there, but you have what you need to go ahead and do the deals. And if that's interesting to you, great. And if it's not, that's fine too. But it's not something that can be just easily described in a 30-minute presentation where you're going to just walk away saying, okay, now I know how to do options. The other thing I want to add is that for me, it became kind of one of the arrows in my quiver. So I come across different deals, and not every deal is going to work for a lease option. It's surprising how many I found now. I never found them until I was looking for them. Until I knew that I could structure it as a lease purchase or a lease option. But not every deal is going to work for this. But there enough do that for me it's been very, very lucrative for my portfolio, especially for my IRA. And Jack touched on that, but combining the options with the IRA is very, very powerful. Unless you have all the money in your IRA that you're ever going to need, and then you don't have to worry about it. But that definitely was not my case. So anyway, that's my 2 cents worth.
Lynn, it's what Joe said. We have some real gems that are not, aren't exactly covered here, but they're in the class. We get into say an hour or so of stuff that's not in the book. And there's real power in those procedures that we learned by doing it. And they really are the strength, but they're not, we don't publish it. They're really not exactly in the book, but this, like the contract for option, there's, we use a contract for the beneficial interest of a land trust. We have a purchase an option back where you purchase something and give the seller the option to buy it back. Jack Miller got a listing option. He'd go walk the streets of Tampa and listing properties, but he really got an option instead of a listing. He had 14% of the sales himself in the Florida Board of Realtors, in the Tampa Board of Realtors, by getting a price that people would sell their house for. He'd have them write it down, and then he'd go sell it and make. He wasn't making the 3% that the realtors make. So you can get an option for managing property. That's installment purchases of notes, installment shared appreciation notes, rehab loan options. I loan money to fixers on properties in exchange for an option on the property. So purchase standard option exchanges. There's one other option that I'd like to mention that we cover later is a defensive option. Are you with me on that? A defensive option is something that you might record against a piece of property to make it look unattractive. Sound? Are you with me here?
Oh, I'm with you. I'm making notes.
Okay. So these are some, we've got, hours worth of ideas that have been tried. This is not like go try it. We hope it doesn't work. If you get locked up, I'll come visit you. But these are little or unusual twists, or just twists that are legal and honest. So, but the defensive option in a class I was doing, a lady went, just hit on the back and, oh wow, that's great, and that's something that you they don't advertise, but people go get mad at you and go look at your properties and see that I have a option to buy it for half of its retail value. Maybe they're not that interested in it.
Hey Jack, I heard a lot of people say that they were lenders on here. I'm a lender, and one way I use options, not just for buying a flip, but how many people do you stumble across that could just really use some money and probably use just a little bit of money, right? One way I've used options over and over again for $5,000 or less. People have given me options in exchange for a loan, and you can kind of blend options with lending and getting tremendous leverage and getting amazing prices. Hey, I'll give you $5,000. Let me just contract to buy your house at a reasonable price. It would have to, a bank would be at 80% LTV. I'm going to be at 70% loan to value. So usually for people who are in crisis, they don't mind giving you 20, 30, 40% off if you can solve their problem. So
Yes, that's very good, and I've used that. And that person needs $5,000 or $8,000. It's not but they have a problem like credit card that's killing them interest, or one guy wanted to make he wanted $8,000, and I said, what do you want for? He says, I need to buy, or have to buy a car for my daughter in high school, and I said, well, that sounds like about 28 payments, and he said, yeah, that sounds fair. And so you're right. That chunk of money is not, they don't want to add it to a credit card. They don't want it, it'll solve a problem for them. And they're happy. I like to do deals where both sides are feeling good about it.
I have a question. This is Alan. I'm trying to understand this. So let's say someone runs out of money. They have a house, you want to buy it. But in the meantime, you want to lease it with the right to purchase it later on. Number one, do you, in your situation, did you generally leave the current seller owner in as a tenant, or did you want it to be vacant? That's number one. Number two, while you're leasing it, who pays the fire and extended insurance? Because someone has to, and if he stops and you never did it, and it burns down, nobody wins. And do you have rehab rights to go in and do things to the property, or do you have to get the seller lessor approval to do that? Those are kind of the questions that I have.
Yeah, they're all, excuse me. We, in a lot of cases, leave the guy in the house. He's familiar. The kids are in school. They're in the neighborhood and churches and whatever. So they're okay with the deal. And this option is it's a lease. It's a I don't call it. It's a lease purchase contract. It's really an option. I can quit and not close if I choose, and I will lose that $8,000. And he's happy. It solved his problem. And we've had a very little problem with people. Well, I have worked on the system that they can't change their mind. After 3 or 4 years, the guy said, well, I decided that I didn't want this. And or he dies, and you're dealing with his son. And the son says, well, I'm not signing any deed here. This house was $200,000, now it's worth $300,000. So I solved that problem. We have that stymied where it's they can't back out, they can't double. We have documents that cover all that. Alex, are we here?
Yes, so let's proceed on to the second portion of the program.
Okay, let's talk about land trust. land trust and personal property trust. It's been my standard way of doing business. I've never done a deal that's not been in a land trust. Mark and I both grew up in Chicago, where the land trust was the law since 1891 in Illinois. You cannot borrow money in Illinois unless the property is in a land trust. I heard my parents, I was 12 years old, talking to his partner, said, we can buy that 4-unit, but it needs to be in a trust. Well, I didn't know. I heard that and it stuck in my mind, but the reason was the banks are not going to loan money unless it's in a trust, and then they use the procedure I use. They hold the beneficial interest for security. So when somebody doesn't pay me, I don't go to court and have to do registered letters and sheriffs. I just have taken houses back with a cell phone call that I have the beneficial interest. So it's powerful, but the people are it's informed or described what the rules are in the trustee. So anyway, the land trust is very powerful. Let's see. Okay. Where's the slide? Trying to get the slides that were up there on the left. Casey, where'd the slides go?
They're coming, Jack. I gotta change the sharing real quick. Hold on just a moment, ladies and gentlemen. Come on. Hey, Jack, can you hit that? Can you click on that land trust and personal property right under Charles's face there? There you go. And hit share.
We hit the share?
Yep. It's lagged for me, so it takes about 10 seconds to throw it through. There we go.
There it is.
And yeah, just hit that from the beginning up there in the top left, Jack.
Okay,
there we go.
So the history of about land trust. When I moved to Florida, and I moved here in like 1979, and I got a license, started buying real estate, and went to a class and a seminar, and all the people were talking about land trusts and blah blah blah, and so we had an attorney in Orlando that were doing a trust for us, and it was expensive, but we drive over there like 4 guys in a car, and he got us going. Then somebody bumped across Mark Warda in Clearwater, and talked to him, and he said, oh, he knows about trusts. He learned it in law school at Illinois. They talked about trusts, so he was familiar, and so he agreed to be our trustee. And so we had, between the 5 guys, we had probably about 25 or 30 properties. So we picked those up, and he became our trustee, and then on to the future. But what of the many features and benefits, I think the greatest and largest of all is the privacy aspect. Many benefits stem from the privacy. It's you're off the public record. The tenants don't know who I am. The bureaucrats don't know who I am, and we treat people well. We don't do any tricky stuff. Mark Ward is a straight arrow guy, and but we use it for defensive purposes and flexibility and trading privately and all that. So the other thing about land trust that it can be used in all 50 states. And there's 6 states that have a statute. Florida, Virginia, and a few others. In the other states, it's referred to as a trust, just a trust, grantor trust, revocable trust. You don't use the word land trust in a state, like a lady in Georgia who was a client. She told her attorney she wanted to do it. He said, no, you can't do that. Just you can't use land trust in Georgia. So she sent me, I said, I went through search and replace. I took land out of the word, all the documents, and she brought it back to the attorney. And he said, oh, well, now that's okay. So it didn't say land trust because he was correct. Georgia didn't have a statute. So it's valid. You can use it in all states, but you do, different states may have a different requirements for the trustee's duties. Like in Florida, the Florida statute 689071 and 073 is the best land trust statute in the country. It says in the Florida statute, the trustee is not liable and the beneficiary is not liable. It says in the Florida law. Who's liable? I don't know. It's not me. It's not Mark. So it's well grounded, and there's years and years of case law. Florida was put in 1963. In the middle of the night, the Florida legislature made a land trust law. And what happened the next day? Somebody bought 27,000 acres next to Orlando in privacy, in a bunch of trusts. Who was that guy?
Walt Disney.
That's right, 27,000 acres. Nobody knew what was going on. You think the last orange grove would have been pretty expensive if they could have figured out, but it was over before anybody figured out what was going on. So it says the Florida legislature is the best that money can buy. It just proves that. So anyway, it can be used to hold notes. Use a personal property trust and mobile homes and other personal things. So, but the best, as I say, the best benefit where most of the things come from is the fact that you're not on the public records. Now the trustee is, and they are reachable, and they have, you can't avoid service and things like that. But compared to an LLC, a lot of people are directed towards LLCs because their attorney may not be familiar with trust or think an LLC. I never use an LLC for a lot of reasons. One being it's on the public records. It has a fee from the state to set it up. It has annual fees, annual reports, a registered agent, all these things in an LLC. The land trust has none of the above. You don't have that. So to me, it's no contest, but that trusts they're better for me. And if people want to use LLCs, they can do it, but I can find it. Bill Gates came to Florida a few years ago, not too long ago, and he bought 300,000 acres of land in up the center of Florida and into Georgia of farmland, 300,000 acres. And the Farm Bureau saw all this land and all the farmers and the grove people were wondering, what's going on here? So it gets snapped up. So somebody looked up who the buyer was, and it was an LLC. So the LLC, so they didn't leave that. Well, who formed the LLC? Well, it was an LLC in Seattle, and they tracked it to Bill Gates. So he should have taken a land trust course and nobody would have known what was going on. But I offered to go to Seattle and do some class. They said, no, they're not interested. They don't want to learn anything about trust. So anyway, other things that happen, and I've seen it happen, is that it avoids probate. If you have a trust and the beneficial of the trust agreement is private document between you and your trustee. And you name your children, your charities, your church, your whoever is your beneficiaries. And if something, you know, God forbid that it does happen to us, car accidents, heart attacks or whatever, somebody passes away, next microsecond, the children or whoever are the owner. No probate, no attorneys, no court cases, and no, say, when is the probate over? I told us when the money runs out. So land trust, it's not necessary, it automatically transfers. There's some less important things like the spousal force share that a spouse can force a property to be divided. I'm not familiar with that, but another big one that I think is a large benefit is judgments don't attach. And say that I have partnered with people, say I partnered with Charles and Casey on a 8-unit or some kind of thing, and we each have a third, and I get in a car accident and I look up, I'm a co-owner in a LLC or some kind of thing. Well, the judgment, the $1 million judgment attaches to our property, which includes them. So the malfeasance by your partner can affect your livelihood and your safety. So judgments can't attach to land trust properties. And it's, they go back to English common law and how it's the trustee is holding legal and equitable title for the benefit of someone else. So judgments don't attach. And litigation is reduced just by the fact that it's not attractive for attorneys to get involved with Morgan and Morgan. We all know who Morgan and Morgan is, signed on the interstate. Have you been injured or whatever? They won't take on a case, a contingency fee case against a land trust. You want to put money on the desk? You have to put money on the desk. And the tenant that had the fall down your steps, broke his back or hurt his back injury, which is hard to see. And he wants to get on disability and sue the owner for a loose tread. You're not going to get a free attorney, meaning an attorney that will take a third or 40, whatever they do on litigation. They won't take that case, in my experience. Another thing that's easier is partnering. You know, 3 people, we each put in a share of money, and we're developing, running a apartment building, and we do this. We can do this in Burger King with a piece of paper on the back. I can assign I want to get out, so I assign my third to Charles. He gives me the money, and then they let Mark know now Charles is 2/3 owner, and I'm not in. So you can go do it without changing deeds and changing tenants in common and going to the courthouse with deeds and then going back and redoing it. You can do it on a piece of paper and without witnesses and notaries. It's transferred as if it's personal property, does not need witnesses and notaries. So it's really handy if you partner with people. And that transfer of interest is from one person to the other. There's a form in the book, assignment of beneficial interest. You sign. If I like to buy properties that are already in trust, or I'll have it put in trust, and then I'll buy the beneficial interest just by an assignment, beneficial interest, and then the moment that I'm the owner, I can fire Mr. Jones's trustee and appoint Mark Warder. But if Mark is already the trustee, then we just say Jack is the owner and Charles is not the owner. So the easy transfer quick and easy, and lots better than doing the deed process. Okay, so you can change the beneficiary. If you've got Mary and Bobby, their kids as your beneficiaries, and Mary runs away and marries a rock star, you just get out your trust agreement, and you get that roller pen, the whiteout pen, and you just run over Mary. She's just got whited out. She's not there anymore. So she doesn't even know it. Of course, if the Mr. Rockstar gets his record hits platinum, then you get out the document and you pencil Mary or write her back in. So she's back in. She didn't even know she was gone. So you can change them. You don't need anybody's permission. You can add them and subtract them. It's your trust agreement, and only you and the trustee are privy to it. There's a strategy that people, you can gift percentages of a trust. Say you have 100,000, get I think it's 14,000 a year. Gift is allowable. I'm not sure, but it's in that range. That you can do 14% this year and 14% next year. And you can segue the ownership of a property gradually over to this child or this person and not pay the gift tax. The foreclosure is a main feature for me for lending. I don't want to go through that court process, and I don't. These IRAs don't want to take people's property. They don't covet the property. They're in it. They want an income stream. But if when it had to happen in 07, 08, I was financing several rehab guys, and they had like 3 properties each, one on the market, one was being rehabbed, and one was waiting. And they had a machine going. They making 04, 5, 6. They were making the guys I was dealing with were making 30,000 a pop on their buy it. Like they were good fixers and cabinets and they looked really nice, and they were on a roll. Well, properties in 07, 08 went down. All my stuff went in half, and so did theirs. So it was a reality, and so I found that a couple of guys were collecting rents and not paying me. So I called them up on their cell phone and told them they just been foreclosed. You've been foreclosed. Bring me the keys, and they did. No sheriff, no registered letter, no court, no nothing. And they brought me the keys. So they because it was well explained to them several times going in. They said, fine, we love it. Lease options, I think, are safer in a trust because of the anonymity, the flexibility of operating with trust beneficial interest and lease options. So we, as I said, when I thought it was clever to give all my tenants an option, then I found out that they had an ownership interest. So with the contract for option, I've had attorneys and I never had anybody complain about that. And then the few I had to take back was simple, it was painless, but it was not a court procedure. So it made my tenant option safer for me that I didn't get trapped. But we were able to convert about 75% of our tenant option buyers into owners because we screened them first that somebody in the household had W-2 income and that could be bankable. And I run them by my mortgage lady, and she said, yeah, I could get these people a loan. They've got a few doctor bills and a few but she couldn't get, she wouldn't approve Mary the babysitter and Bob the handyman because they didn't have verifiable income. So the other, having the tax assessments lower in the day of the taxes going up rapidly as the prices were going up, since the tax assessor doesn't get to see the sales price of your property moving, they don't have the automatic index applied as they did in the day when, as soon as they saw another transfer that was 20% higher than the last one, they jack up the taxes 20%. So, and the other one is the public record doesn't show the sales price. So I know it, you know it, but it's we pay doc stamps on a DRT 228 to the state, and we say this is for $100,000. That's $700 doc stamps on trust 205, trust 205, and we get a canceled check back, which we staple into the folder in case we're audited. Here's the check we paid the tax, and the liability limitation. So overall, there's lots of benefits that you accrue with. You get, it's like health insurance. You get into a trust, you get all of these whether you need them or not. If you have a balance sheet that you're interested in showing assets, it doesn't show liabilities. Partition is not available. That's I think a spousal thing that, or partners can force a partition of a property, and you're in an investment property and one partner wants out and its cash is not available. So he has a partition lawsuit. I think is messy and expensive. I haven't been involved in it, but as I said before, to avoid liability for your partner's action or accidents or problems. Does it save on title insurance? I'm told that it does in some instances. Avoid real estate broker laws. Well, I know people that buy and sell real estate, but they buy and sell beneficial interests. They don't buy and sell real estate, and they don't have to be a licensed real estate broker. So if I did that, I wouldn't brag about that in public and take on the realtor organization. It's I know people that do it sub rosa, and they don't have a problem. And getting towards the end, that's the tenants can't contract the owner. You're not going to have the phone ringing at 3 in the morning about a drippy faucet, and that my wife Merle has a low tolerance for angry tenants about stuff, that fix this and come over and do this. So they do not have a phone link, and in one mobile home park that I know about, the inmates where the people wanted to talk to the trustee or the owner. And I said, well, I just have a courier service. I just come here to pick up the rents. I don't know. I'm just a courier. And they had no idea that I was the owner of the place. So they want to talk to the owner. I said, well, why don't you look it up on the public record? So they said, yeah, we know how to do that. So a couple of weeks later, I was there and I talked to the misters. I talked to one of the wives. Said, how did the meeting go with the owner? She said, damn. We went into the public record. We found the owner was Land Trust Service Corporation, P.O. Box 187, Lake Wales, Florida. So they couldn't even get a hold of Mark Orta personally. You can write him letters. But anyway, all the kind of code enforcement bureaucrats, angry, ex-wives, angry neighbors, all these people. As long as you don't we treat people right, we obey the law, but we don't get harassed You also don't get any sales calls. You don't get anybody trying to sell you stuff and get your email, get bombarded with insurance. So anyway, that's to say that course. This course is on my website with the all-day video. You get Mark Warda's book, and if you deal, I get this Warda's book, Land Trust in Florida. It's got all the Florida law in the CD and all of that. If you deal in other states, you get the trust book that's valid in. It's got a page for every state and what the trust deed duties are. So that's everything I know. Alex, we have some questions.
I have a question. This is Alan. If a person says, look, I want to put my assets in a trust, and they do, and they are the trustor, the trustee, the beneficiary, and everything until they pass away, and there are successor trustees and the successor beneficiaries, their kids. When the one who started it passes away, first of all, they didn't have to turn in a separate tax return. Now it goes to the kids. Can they still use that same information and simply divide it, or do they have to apply for a new federal ID number or something so that when it comes to the kids, it is divided up differently or shown for the IRS?
You know, I don't know the answer to that question. First of all, I know that Mark Warda and I'm friends with the attorneys and Martin Edwards and trust attorneys in Chicago. It's highly recommended that you don't be the trustee and the beneficiary. So, and doesn't mean you can't do it, and it may be convenient. I'd say see if you can find a sister-in-law or a friend with a different name, and they're not liable. They're very well protected, and have a different name. So I would ask maybe some of the attorneys on the call or people that know, but I think that's probably a straightforward question for an attorney, and I don't want to take a stab at it.
Thank you.
So I like to use a business entity as the trustee because it's not mortal. So that will continue as long as you.
Say then you like to use a what for a trustee?
A business entity,
Sure.
a corporation or an LLC as the trustee, so it doesn't have mortality.
Yes, a lot of people, Mark, would recommend that you use an LLC for your trustee. It survives. It's not got as much paperwork as a corporation. So LLC is a good choice as a trustee.
But the problem that I have, and I used to put a lot of LLCs and corps as a trustee, but the problem that I see is the trustee is not liable whatsoever. There is no way to make the trustee liable. But if the LLC is a trustee, you can find the manager and member manager of the LLC, and you can sue the members of the LLC. Am I right? So you lose privacy. You put an LLC or a corp as a trustee because you can.
Right. But John, the trustee doesn't have any liability, so it doesn't matter.
Yeah, but the member of the LLC does.
No, the
Personally.
trustee has no liability under the trust statute, so they don't have to worry about being sued. They're not a defendant.
No personal liability.
Yeah, Florida statute says 689-071, 689-073. And by the way, those documents must be in any trust documents, or you don't have a valid trust in Florida. But that, as we said, the Florida statute says the trustee is not liable and the beneficiary is not liable. So it's what could be better than the statute saying.
I have a question. how is it that I can be sued when I had a land trust and I had a beneficiary? I mean, a trustee, and I was the beneficiary.
How did they know who you were?
I think it was the condo association.
Oh,
You mean the land trust was sued, or were you sued personally?
I'm being sued personally, and my trustee is named on the lawsuit too.
I do not know the answer to that question. I'm sorry. I think either Mark Warder or one of these attorneys sounds a little irregular, but condo associations are not known for behaving in a rational manner, especially with their owners committees and stuff, telling everybody what to do. So
You have to pretend, I guess you have to pretend that if you are being a landlord and taking care of everything, you have to pretend like you're working for somebody. But then if you're working for somebody and they ask you, well, who do you work for? Then you're,
for the trustee, you're the property manager,
yeah,
and it's suggested you have a property manager,
Yeah.
and he works for the, as I told the people in the mobile home park. That's all I know is I'm told to come and pick up the rent, and I turn it into my pocket is what, but I turned it into the trustee, and so they didn't get mad at me, and I tried, I was friendly with them, but they wanted to get to the trustee, and it's not always possible. Owners Association, because they probably know you live there, parking and all that. That's tough.
but when you go to a
Hey,
condo,
Wendy?
yeah,
That does bring up a situation that happened to a fellow real estate attorney of mine. He was doing a closing for a celebrity. He closed in a land trust, but here's where he made his mistake. On the condo certificate of approval, he put his
Yeah.
name.
yeah.
So if you're going to be anonymous, you got to make sure that nothing is recorded with your name on it. So if it's a condo, you're going to have to work with the condo association that they named the trust as the approved party and not the person.
Yeah, I'm not
So
sure
that
they're,
celebrity got outed, and the next thing he was in the newspaper, and he was really mad because he thought the trust would hide him, but
yeah.
his name was on the certificate of approval attached to his deed. So much for that.
And the condo associations, you have to go in and have an interview. So who do you send in to have that interview? If you're naming an entity as the owner, I mean, I don't know. It's a little complicated.
Well, yeah. Sorry, you want to answer that, Jack?
What about the condo association?
Yeah.
Well,
You have to go in for an interview after they, in the approval process to buy the condo. You have to have an interview in person.
yeah. I have dealt with condo associations. I don't know. I've optioned a condo, and it was a rental condo, and the numbers were pretty good, but I didn't know about when the tenant left. They had the owners committee that had to approve my new tenant. Well, they only met one Tuesday a month and all that, so a couple months of vacancies, and then they didn't. There's all these retired guys that want to flex some muscle. They didn't like this tenant and that tenant, so I decided that I didn't want any more condo associations approving my tenants, and I eventually got out of it. But I don't know. They're like rogue organizations in my book.
Yeah, I've been through all of that too, but what I don't know how I would be able to get around if I was to buy another condo is, if I had all these documents in place, but then when they say, okay, now who's the owner and who's gonna answer all our questions for the interview to allow you to become a part of the association.
That's the best strategy.
Can I
Just
add
avoid
something?
condos.
Can I add something?
Yeah.
Wendy?
Yeah.
Just keep in mind that condominium associations, and Alex or another attorney can verify this, that to stay within the law, they only have to be fair, follow the law for protected groups. And condo associations have a lot of ways, in a very veiled way, that they practice a lot of discrimination. So you have to be very wary when you're dealing with condominium associations, because there's a lot of ways that they can discriminate without breaking the law, as long as they don't involve themselves with any of the protected, by law, protected, protected classes. Is that right, Alex? Or Basil, whoever's there?
Well, I'm sure that's right. I'm guessing you're right, but I mean, it's too late for me. I already have condos, and they already have, me having gone into interview as the
How do I
owner.
get back on the screen with all the people?
Well, that's why you're saying you're thinking about buying more condos. That's why I'm saying, there's risks you're taking there for a lot of reasons. For a lot of reasons.
A lot.
Maybe it works for you, maybe it doesn't. You can rethink it. So
I mean, that's the thing. That's the one little glitch. Otherwise, it has worked for me. I mean, I checked my places out good before I bought them. I checked the condo associations out first. And so I avoided some of those problems. One of them has in their docs, they say that that they won't allow a Section 8 in the unit. No Section 8's allowed. I thought it would probably be against the law, but it's old and it's in the docs, so I guess it's respected.
Great. Send me their information because they can be sued.
way to go, Alex.
All right.
So I can tell you guys a deal that I did a few years ago. I bought a condo and it was 55 plus. I didn't even buy it. I took over the mortgage. I took over the mortgage on a 55 plus.
Oh, I don't see the other people.
With a trust. Now, the guy that wanted to buy the 55 plus condo was another investor, and he wasn't 55, he was about 40 years old. So I sold him the trust, and he brought his father, which was about 70, to be interviewed by the Condos Association. So in the Condos Association docs, the trust is the one who owns the property. The father was the one who got interviewed, and after the father got interviewed and it was approved, the 40 years old investor moved in. I don't know how he pulled that one, but he was there for years.
But if there was a lawsuit in that unit, the person who is now on that document could be sued because the condo association could give away their name.
Well, I guess he live in the house. I guess once, there is a lot of 55 plus, so there is people under 55 living in there.
That's not what I'm trying to say. What I'm trying to say is, if something happened and somebody who lived in that condo decided that they were injured by something and wanted to file a lawsuit, they could file a lawsuit against the guy who owned. Yeah, the owner. So that's the question. How do you keep the ownership out of the knowledge of the condo association when you
how are you going to sue? The owner is the trust. You cannot sue the trust or the trust.
Really? I'm being sued in my trust.
Well,
yeah, I think, can I just interject for a second, John? I'm sorry to interrupt.
Yes.
And I'll defer to Alex for what I'm about to say, but I think we have to distinguish between personal liability and liability on the property itself. So are you being, the statute doesn't say you can't be sued. You can be sued for the subject property if you're negligent or whatever. I mean, anybody can be sued for any reason, but the property and the trustee there can be a lawsuit against the trust for the property itself if there's negligence involved in the property. Is that correct, Alex? The question is, does the judgment that they might get extend beyond that property? That's what you're protected from. So if you have 10 properties, only that one property is going to be the subject of the lawsuit, not your other 9. And that would apply whether you're the trustee Or I think, John, that's a great idea, John. I love that. You simply have the father be the beneficiary of the trust, and you have them go in and talk on behalf of the trust as the beneficiary rather than the trustee. But either way, you're covered under the trust in the lawsuit.
He got approved. I mean, the guy got approved, and the investor moved in with the father. Actually,
Yeah.
the father never lived in the house. The investor lived in the condo.
Yeah.
Right, so I agree with Charles. Going back to what Jack was saying, I started off as a prosecutor in Chicago, and as Jack stated, there literally is not one commercial property in Chicago that's not in a land trust. So every lawsuit we brought, the defendant was a trust. The trust didn't eliminate liability completely. It's just we would name the trustee and then subpoena the trustee to divulge the beneficiary. The trustee in Chicago is almost always a bank. So the bank would tell us who the beneficiary is. We would dismiss the trustee because the trustee has no liability. And then we would proceed with the beneficiary as the defendant. So the trust itself doesn't protect you from liability. If you want liability protection, then you want the beneficiary to be a business entity, like a corporation or an LLC.
Wonderful. Period. Thank you. Mucho.
So also, the best protection from liability is to have insurance, because they're your first line of defense.
Well,
But
they
as-
can always,
But as you stated, Charles, there's no bleeding lien in that a judgment against that property is not going to spread to other properties. And
Okay.
as the title insurer, I've seen that plenty of times where a person owns multiple properties, they get some sort of a little fine for code violation like parking on the grass. And once that's recorded, that hits every property. So if you had every property in a different trust, the lien is not going to spread from the one property to all your properties, because each trust will have a different name. So that is help. And then Jack touched on title insurance. The reason a trust could save you on title insurance is that title insurance insures the title holder, which would be the trust. So if you change beneficiaries of the trust, you're not disturbing the title holder. So that insurance policy protecting the trustee and the trust remains in effect. But if you had a property owned by Charles Hayes and you quitclaim it to Joe Hayes, the title insurance is canceled. But if he switched beneficiaries to a relative, he still has his title insurance. So that does save you money. Also, with property taxes, whenever there's a conveyance recorded, they reassess your property. You lose any grandfathering you had. So changing beneficiaries protects you from being reassessed. And I am happy to report that in Broward, our property appraiser, Marty Kerr, is so knowledgeable about trust, he even has the form on the front page of his website to homestead a trust property. So being in a trust does not deprive you of homestead if that's where you reside. But
Yeah.
I would caution you that in Miami-Dade, if your trust states that the property is personalty and not real estate, Miami-Dade will refuse you a homestead credit. So don't write, this is now personal property and date, or you'll lose your homestead.
Yeah, I forgot to mention that, Alex. It's a good point. My home is I have the tax exemption. You need a life estate deed. You need a possessory right to life for life, and then you can get a tax exemption for your homestead, the life estate deed. Is that Edison hiding out down there?
He doesn't like to show his face, but can I just say hi to Mr. Shea?
Yeah.
How you doing,
David.
Mr. Shea? It's Dave Feldman here. I don't know if you remember me. I met you a couple of years ago when you were down here with your live presentation. I bought you a couple of drinks at the hotel.
Yes, and
pilot to another.
I'll return the favor, David. That's, if we,
No.
I noticed Edison hasn't been inviting me back lately, but Alex, tell you this, this group, it's enjoyable to mix with knowledgeable investors. Everybody's bringing something to the table, and I get great enjoyment, but great information. I'm taking notes all the time when with a group like this. I mean, this is tough. You can't know everything about this topic. It's too broad and it's too deep, and we've all had different experiences. And as you know, I call them seminars, is to avoid some of the seminars I have had with somebody on this, you know, bring up a topic, if you don't do this or do this, and it's, I know people I deal with at 1031, they're not doing well. I see their math and their numbers, and I say, do you ever go to a real estate meeting in Denver? Or just, no, I don't need that stuff. I don't need those guys. And they do, you know, they wouldn't be making the dumb mistakes, but they would be upbraided in a meeting like this. But some people are too proud. No, I don't need those real estate meetings. And I'm looking at their math, and they would benefit. They'd say, those real estate meetings. So you're right, David. And I do remember, and I'll return the favor one of these days.
Thank you for sharing your information with us again. I did have something to add on the insurance, Alex, for the group. If somebody wasn't there at one of our other meetings, the insurance lady said, you have to be careful with changing title to your properties as far as property insurance, because if the property insurance finds out you transferred your property from a personal name to a trust or an LLC, it could void your property insurance coverage entirely. So if you try to file a claim, they won't honor it because they say this property's not in your name. So you have to be careful with that. And I think we had an answer to that, Alex. You gonna say something?
Yeah, if the insured on the policy is not the homeowner, you're not covered. So if you change title, you've got to change the beneficiary of the policy. When you have a trust, you're going to have the trust as an insured and the beneficiary as an insured.
Well, there was also
The main thing is, if you get a check from Citizens, you better be able to cash it. So, make sure someone's able to sign that check.
But when you're buying, if you're buying the property in the trust to begin with, will that work for property insurance?
Yeah, where people get in trouble is that I have a house owned by Alex Johnson. I take out my windstorm for Alex Johnson, then I convey it into the 123 Main Street Trust, Land Trust Services Corporation trustee. Now I'm not covered because Alex Johnson doesn't own the property. The trust does. Alex Johnson's the insured, but he's not the homeowner. So if I get windstorm damage, I'm not going to be insured. So I need to, if I change the ownership, I have to change my beneficiary on my insurance.
So who's going to be the beneficiary? The trust and the beneficiary of the trust, both of them?
Right. It depends on how important it is to stay secret. For me, secrecy is not the objective. So I have two beneficiaries, the trust and the beneficiary. They're both insureds.
Okay. So when you get a check,
it'll be payable to the trust and it'll be payable to the beneficiary.
All right. So you're going to have to open a bank account on the name of the trust, I guess.
No, you just have to sign as trustee and then sign as beneficiary and then put it in the beneficiary account. I don't have bank accounts for the trustee or the trust.
That's a great idea, Alex. I like that.
Yeah, this just
one more short question, if I could. This is Alan. Mr. Shea, first of all, thank you very much for your time. If you have a library and you looked at it, other than your own books, what other two books would you recommend we have, one on lease options and one on trusts, as an addendum to whatever you have in your course? There's got to be more than one book out there, and sometimes it's good to read. There's wisdom in the multitude of counselors, it says somewhere. And do you have other books that you would recommend or that you could put on your website?
Alex,
Alan.
I've scoured the web. I cannot find another book on lease options. I don't think anybody has plumbed it. I don't know if it's there. If it is, I will guarantee that they haven't figured out how to depreciate the property and how to do this and that. So I will look. Okay, I will look, and if I can find what do you land trust for?
Yeah, that's the Mark Warda Land Trust book.
Okay, well, there's other land trust people. I would just Google some. I think Pete Fortunato, John Schaub, people I know that are respectable, wise people and hands-on investors. Their stuff is good. I go to their, we go to each other's seminars. So I would kind of look for players rather than marketeers or something that want to make you rich and famous. So I
Thank
will
you.
look for an option book. I'll tell you, if you find one, let me know. I'm always up to learning stuff, but I've made enough expensive mistakes that you're benefiting from the seminars that I got. I want to mention one thing, Alex, that I'm just looking at my notes that I don't think I covered in before we leave, is that you have a deed into a trust, and Mark Warden and I found out this to be true, that we recommend that you have 2 successor trustees. If you have one trustee, we've had Ernest too here, had a stroke. He was in a coma for 9 weeks. And when he came out, he was non-compos mentis. He couldn't sign. So you don't want to be painted into a corner. If your trustee dies, she's on a cruise ship to China or climbing Mount Everest or something. So having 2 other people in the courthouse, and I say, you don't even have to ask. You could put your attorney in there, your reverend, your cousin. And if, it's 1 in 1,000 or a rare event that person is unavailable or incapable, you don't have a property that you can't get rid of, because those other 2 people, either one of them can sign a deed because they're a successor trustee. So we have that as a hallmark, and Mark is a trustee for over 1,600 trusts. And it's kind of our standard MO, and I forgot to mention it. So that's important to not be. Now, if you have a trustee like Land Trust Service Corporation, a corporation is by trustee, that won't die. But if you have a person that's susceptible to, now also people, I've known cases from where their trustee got testy and started changing the fee from $200 to $2,000 and wouldn't do this and wouldn't do that. Well, you want to pull the lever, gone. And so I know of cases where the trustee went rogue on the people, and that was the guy in Clearwater, Bob Hughes. He decided he'd go to a closing and he'd look at the profit that this Billy was making of $20,000 on this duplex thing she was selling. He insisted on $4,000 or he wouldn't sign the deed. And she gave it to him. So that's a safety valve that, spread it around or do whatever. So thanks for the question.
I have a question for Jack. Jack, I had this situation a couple of times in the past. I know there is a document in the trust. I don't recall the name of it. It's very, very unusual, but it's a document when a real estate attorney is doing the closing. Some attorneys, they want to see the full trust with the beneficiaries of the trust, which they should not get it because that's private. But instead, they should get a piece of paper what is telling you, like an outline of the trust. What do you do, or what have you done when the attorney wants to close and they won't close unless they see the full trust with all the beneficiaries? What do you do in that case?
Okay, good question. Who is that, John?
Yes.
Uh,
And I've been there a couple of times, and it's hard.
okay, here I'm gonna find it. It's called a,
I have it somewhere.
okay, a certification of trust, 103. Okay,
Yes.
here's what that says. It's in the book, and it says, it says, it's a document that says the trust is current, it's valid, that the people are still the same as, you know, as listed, and let me see. Certification of trust is a form. The form is included in Florida Statute 736 dash or point 1017, and it states that, you know, it's current, that some closing agents have asked for it. The certificate of trust, when the property is sold by a trust, that is not a land trust. That's a different thing. The certification of trust is just stating that the trustee is the same, the beneficiary is the same, and that should make title companies. I've had them ask, even though we tend to, Mark and I have title companies that we deal with on a regular basis. But years ago, we've had one case, we've had to pick up the documents from the closing and just leave and go down the street and find there's lots of title people. And so now we have our team, and I think you will find yours, but that should help. That makes sense?
Yes, you know, a few years ago, I had a case like that with a high-end attorney in Coral Gables, $500 an hour attorney. I say, I'm not closing unless you show me the trust. I was a seller.
Yeah.
I say, I'm not showing the trust. I just don't want to show it to you. So I send in that piece of paper, and I told him, that's good enough for you. If you don't close, eventually you could be sued. And you know what? He closed because that's all he needs. He doesn't need to see the trust, the full trust.
Yeah.
Do you mind if I add a comment?
Go ahead.
Go ahead.
Okay, so as a real estate attorney, I see that happen all the time. Obviously, if Bill Gates' attorney doesn't understand the land trust, there's a lot of other attorneys that don't understand the land trust. And certainly title companies don't even know real estate law at all. So if you have a property in a trust, you should probably do what Jack suggested, which is make sure you control who's doing the closing so that some ignorant attorney or title company isn't making you do things that are improper, like divulging the trust. Some will even try to record the trust. So if the property's in a trust, you may want to put in the contract that you will pick the title company so this doesn't happen. Obviously, what happened to John, I don't know how many hundreds of dollars an hour that guy charged. He was wrong, because if the property's in a trust, the trust language is on the deed, there's no need to divulge the trust. It says right on its face, it's in a trust, you cite to the trust statute, and that's sufficient. Or maybe, as Jack said, give the certificate. Yeah, the trust is still in existence. But really, the best thing is to make sure you pick the closing agent. Then you won't have the last minute hassle.
Can I add something? Can I add something about that as an end user of the trust, and the things I've come across is that a lot of times attorneys, a seller will send it out to their attorney, and this is kind of picking up on what Alex was just saying. They'll send the trust out to their attorney, and the attorney doesn't want to spend 8 hours ordering Mark's book, learning about trust, so he tells them don't do it. And the fact that a lot of attorneys the present company excluded don't understand land trusts is precisely, I think, what Jack has often said he likes about them, and what I like about them is that, you know, there's very specific things in a land trust that the opposing attorney has to do if they're suing you, and a lot of them don't know even those basics, and certainly they don't know some of the sort of finer points of how the trust works. So so if you're going to use a trust and you order Jack's course, or you hopefully go to Alex and get a trust set up, and you're told by someone out there in the world that the trusts don't work or you can't use them, that's not true. And they do work. And the statute actually, the statute specifically uses the word, I think it uses the word, no one is obligated to see the trust, but not that nobody's allowed to see it, but just they're not obligated to see it as a condition of closing or for other aspects of doing business with the trust. So sometimes I've had that wording come up. The attorney will say, I'm not obligated, but I want to see it. Well, what they want to do is not our concern, right? So anyway, those are my 2 cents worth. Pretty much whatever somebody tells you can't work with the trust, yeah, I found that there's a way to make it work, and especially with the insurance, I've had that come up in the homestead. That has come up, and I've gotten through that successfully. I call Jack and try and stump him with dumb questions, and I never can stump him. He always has the answer.
I had a problem with the bank that they wanted to see the trust. It had to do with opening some account, and I kept insisting that they couldn't see it, and they kept insisting they had to see it. And I can't remember where we left off, but I think I didn't open the account.
Yeah, my research, if I could add my 2 cents, is from what I read, you like Charles said, you're not obligated to show it, but what you might do is just show the first and last page of the trust. You don't have to give them the whole trust, just to show them that there is one available.
That's what I did do that. I did offer that. It still wasn't enough.
So that they should accept, or otherwise threaten them with the lawsuit. So Jack, I don't know if remember, one of my claims to fame for the group is that I have a very large real estate library. So it took me a minute, but I did find a book. You probably know this one already, on lease options. I don't know if you can see that.
And who's that by? Lease option? Who's the, is that Dyke?
Mr. Legrand, Ron
Oh,
Legrand.
Ron Legrand. I forgot about him. He was the famous guy from Jacksonville that, yeah, okay. Yeah, Ron Legrand showed up in the early 80s, where his first show up was that he had 1,100 properties. That was his come out the gate. I knew people had, you know, some, but Ron Legrand had 1,100. So he was big in numbers, and he was also big on copying other people's stuff. And he was kind of a empty suit kind of guy, big on promotion, big on advertising and all that, but I'd say short on, you know, his own knowledge, I would say his own knowledge. So anyway, I don't think he's around there, but thank you. He was an expert at that time, yes.
He is still around, and what do they say? Imitation is the sincerest form of flattery, so maybe that's what he was doing, I don't know.
Yeah.
But anyway,
Well, he was a carnival barker. I mean,
yeah, and I actually ate lunch with him once about 30 years ago and bought him a couple of drinks. I won't be doing that again, though, neither. So he's a good guy, but I mean, he's good in real estate, but otherwise I can't have much to say about him. Anyway, that's it.
I stand corrected, David. Thank you. You probably have a collector's item there.
Yeah, exactly. But he is still around. He's still doing seminars, and he's on the internet. If you want to look him up for some YouTube videos.
He's still around?
Yeah, he is.
Yeah.
Yes, sir.
So I have a question for Alex. I wanna take advantage of freebie. Getting an attorney for free here is a good thing. So Alex, I have a question for you, please. I'm doing a deal right now in Miami. I'm buying a default mortgage. This is a mortgage. Actually, it's a hard money mortgage that is 5 months behind, and it's in default. So I'm buying that mortgage. Now, the question is this. Once I buy the mortgage with all the late fees, which is there is a lot of equity on the house, how is the foreclosure business going on right now? How long is it going to take me to foreclosure in the courthouse in Miami-Dade County? Do you have any news about the foreclosure with this pandemic?
The CARES Act has an injunction on any foreclosures until July 25th, so that's not going to be a problem much longer for you. The governor's stay on writs of possession is supposed to expire August 1st, but frankly, a lot of us are worried that since Florida has only been getting worse with the pandemic, that he might extend it another month, which will be extremely bad news for landlords that haven't got paid rent since March. But the governor never tips his hand until the last day, usually at 8 o'clock at night on the day the injunction is going to expire. So we're not going to know. Obviously, in a foreclosure, it's going to take you maybe 4 months to go to judgment if the borrower doesn't declare bankruptcy on you, or stall you with discovery. But at the end of the day, you need the sheriff to come out and execute the writ. So that's what's up in the air, whether you get your writ. The other thing is that it's been 3 months of writs piling up, so there might be a big backlog. And Dade was always very slow anyway. I mean, a minimum of a month. So now they got a 3-month traffic jam. So I don't know how long it'll be for someone to come to the front door and turn the people out.
So if I buy this mortgage, it's a rehab house. The house is vacant, by the way. So if I buy this mortgage, it could take me a year before I can sell the mortgage in the courthouse and take over the deed, right?
It shouldn't take a year. I mean, especially if it's uncontested. But if it is contested, it could take a year. I made the mistake of buying a note on a hard money loan back in the crash. And that borrower did declare bankruptcy. He did fight the case. So even though I was my own attorney, it did take a year to get the property back.
So if they file for
that's only when the case is contested.
If they file for bankruptcy, what happened from there?
Then you got to go into bankruptcy court and have the stay lifted. Normally, bankruptcy is not, the only reason a bankruptcy would have any effect on a foreclosure is if there's a lot of equity that could go to other creditors. If the amount owed to the lender is close to the market value, they'll lift the stay and take the house out of the bankruptcy because there's nothing to distribute to other people.
It's $150,000 in equity.
All right. But since it's 2 o'clock, I'd rather have anyone who's got a final question for Jack. This is your chance.
Okay.
Otherwise, I wish everyone would give Jack a round of applause for donating his afternoon to us for free. So.
Yeah, well, I enjoyed it. Alex, thanks for doing this. And I just reminder stuff, jackshayrealestate.com has information, but it has these 3 courses. One that we didn't talk about is an IRA checkbook, control how you get your money in your corner bank. And we know how that, or I mean, I do it. And I don't have to go through the custodian, and all the rents and no payments go to my corner bank. So there's stuff that I have, and it works, and it works for lots of people. And I answer questions, and I'm happy to help you out. And I took some notes today from some things. So I was listening and learning, and thanks for inviting me, Alex. Thanks again.
Thank you, Jack, and thank you, Charles, for putting this all together for us.
My pleasure.
And as Alan Johnson used to say, you all make the meeting. Next week is going to be a little bit different. We've got a special presentation from, one second.
Some Tony Robbins person.
Thank you, Wendy. It's a senior moment. So next week, because we got raided the last time Tony Robbins tried to come in, they're gonna host the meeting. So look for a new invitation for the Tony Robbins site. It's not gonna be the regular sign in for my Zoom room. It's gonna be Tony Robbins Zoom room. The address will be in the newsletter on our Facebook page, which is Real Estate and Business Network on Facebook, and on our meetup.com page, Real Estate and Business Network. So the link will be in any of those three spaces, or you can email me personally at aj@browardlandlord.com, and I'll personally send you the link. So I look forward to see everyone for our motivational session next Thursday at noon.
Any news from Dawson?
Not a word. It is bizarre.
Wow.
Attorney Zakar is representing his mother. He says he's here in Fort Lauderdale, out and about. But I haven't heard a word from him since the end of May.
Well,
It's
I'm
really
sure he's
weird.
going to come back. We'll see him
He is.
one day.
He was at Denny's yesterday. Yesterday. He came before the exchange meeting started yesterday.
And he didn't say a word about Real Estate and Business Network?
Well,
No,
it's
kind of got